Robert Chin is a 54-year-old pharmacist in suburban Ohio. He served 3 tours in Iraq. He has a spotless criminal record. He owns 12 firearms, all registered with the ATF, all stored in a biometric safe, all documented according to every federal and state requirement. He has never had a complaint filed against him. He has never been involved in a single incident. He follows every rule. On a Thursday afternoon in March, 2 ATF agents knock on his door. They have a warrant based on an alleged paperwork discrepancy from 7 years ago. A single form filed with 1 incorrect serial number. A typo that Robert never caught. A mistake that nobody ever informed him about until federal agents showed up at his home with their weapons drawn. Robert is now facing a federal felony charge that carries a mandatory minimum sentence of 5 years in prison. His crime was not violence. His crime was not threat. His crime was not intent. His crime was a clerical error on a form he filled out 7 years ago, and a Supreme Court ruling that most Americans have never heard of just made that clerical error prosecutable as a felony. This is not a drill. This is not an exaggeration. This is the new reality for every single gun owner in all 50 states, and the mainstream media is refusing to cover the story that could destroy the Second Amendment rights of over 100 million Americans. I am going to tell you exactly what the Supreme Court ruled, why it matters, what trapdoors it opened, and most importantly, I am going to give you the complete defense protocol to protect yourself and your family from becoming the next victim of this ruling. But first, if you own a firearm, if you have ever filed an ATF form, if you have ever purchased a gun, you need to subscribe to this channel right now, because what I am about to explain to you could be the difference between keeping your freedom and losing it forever. So, guys, let me take you inside the Supreme Court chamber where 9 justices just changed American gun laws forever. The case is called United States versus Harrington, and it originated in Texas when a collector named David Harrington was prosecuted for what the government called a willful failure to report a firearm transfer within the required time frame. Harrington claimed he mailed the form on time, but it was lost in the mail. The government said the postmark did not matter. Only the receipt date mattered. Harrington fought the charge all the way to the Supreme Court, and what happened next sent shockwaves through the entire American legal system. The justices issued a unanimous 9-0 decision that redefined what willful means in the context of federal firearms law. 9-0, not 5-4, not 6-3, unanimous. That means every single justice on the court, regardless of their political ideology or their personal views on gun control, agreed with this interpretation. Here is what that means in plain English. Under the old standard, the federal government had to prove that you deliberately and knowingly broke a law you were aware of. They had to show criminal intent. They had to prove that you knew the rule existed and chose to ignore it anyway. Under the new standard created by the Harrington decision, the government only has to prove that you were in reckless disregard of a legal requirement. In plain English, that means even if you did not know a rule existed, even if you made an innocent mistake, even if you had no reason to suspect you were doing anything wrong, you can still be convicted of a federal felony if a prosecutor decides your conduct was reckless. This is a massive shift. This is a fundamental restructuring of the burden of proof in firearms cases, and it applies to every single gun owner in all 50 states, not just the people involved in the Harrington case. The media is ignoring this. You will not see this covered on cable news. You will not hear political commentators debating this on Sunday morning shows. But constitutional scholars are calling the Harrington decision the most significant expansion of federal firearms enforcement authority in 30 years. And it is already being used to prosecute gun owners who never intended to break any law. I spent 6 weeks researching this story. I talked to constitutional attorneys who have been fighting these cases for decades. I talked to ATF compliance officers who asked to remain anonymous because they were afraid of retaliation. I read the full 87-page opinion, so you do not have to. And what I found is a systematic assault on the Second Amendment rights of ordinary Americans, hiding behind legal language that most people will never understand unless someone explains it to them clearly. Now I need to explain the trapdoors. These are the hidden dangers that the Harrington ruling has opened up, and they are more dangerous than anything the gun community is currently discussing in forums or social media. The first trapdoor is called the compliance window shrinkage. Under the old legal standard, if you made a mistake on an ATF form, you had time to correct it before it became a prosecutable offense. The government had to prove you were aware of the rule and deliberately chose to ignore it, which meant they had to give you a chance to fix the problem first. Under the new standard, that window has been eliminated. A single clerical error can now be treated as reckless disregard from the moment you file the form incorrectly. You do not get a warning. You do not get a chance to fix it. You simply have a felony on your record the moment the form is processed wrong. The second trapdoor is called the constructive possession doctrine. In plain English, this means the government can now charge you with a firearms violation based on your access to guns, not just your ownership of them. If you live with someone who owns a firearm, if you have a key to a safe that contains guns, if you have ever helped someone move a firearm from one location to another, you can now potentially be charged as a constructive possessor of that weapon. This is an enormous expansion of criminal liability that affects millions of Americans who have never owned a firearm themselves, but who live in households with gun owners. The third trapdoor is what I call the interstate commerce expansion. The federal government has always claimed authority over firearms based on the Commerce Clause of the Constitution, which gives Congress the power to regulate interstate commerce. Under the old interpretation, this meant the government could regulate firearms that moved across state lines. But if you bought a gun in your home state and never took it out of that state, you were generally protected from federal prosecution for purely intrastate transactions. The Harrington ruling has changed that. The Supreme Court upheld an interpretation of the Commerce Clause that legal scholars are calling unprecedented. In plain English, this means the federal government can now claim jurisdiction over virtually any firearm in any state, regardless of whether that firearm has ever crossed a state line or been involved in any commercial transaction. The ruling allows prosecutors to argue that any firearm affects interstate commerce simply because firearms and ammunition are manufactured using components that moved across state lines during the manufacturing process. The fourth trapdoor is the most dangerous one. It is called the retroactive application doctrine. The Supreme Court ruled that the new definition of willful applies not just to future conduct, but also to past conduct. This means that if you made a paperwork mistake 5 years ago, 10 years ago, or even longer, that mistake can now be prosecuted under the new standard, even though you filed that form before the Harrington decision was issued. The court ruled that the change in interpretation is a clarification of existing law, not a new law, which means it applies retroactively to every form you have ever filed. This is why Robert Chen, the pharmacist from Ohio I told you about at the beginning of this video, is now facing federal charges for a form he filed 7 years ago. The ATF is using the Harrington decision to go after gun owners who made any paperwork error in the past decade, and the new legal standard makes those old errors prosecutable as felonies. If you have any family member who owns a firearm, if you have any friend who has ever purchased a gun, you need to share this video with them immediately. But first, make absolutely sure you are subscribed to this channel so that our future updates about state compliance deadlines and new enforcement priorities go directly to your phone. The situation is evolving faster than most people realize, and the next update I release could contain information that saves your freedom. Now I am going to give you the complete master protocol. This is the system that constitutional attorneys and firearms compliance experts are telling me is the most effective way to protect yourself under the new legal landscape created by the Harrington decision. I am going to give you 8 steps that you can implement starting today, and every single step is free except for the cost of your time and attention. Step 1 is about your paperwork audit. Right now, today, you need to gather every single firearms-related document you have ever filed with any government agency. This includes every ATF Form 1, Form 2, Form 3, and Form 4 you have ever submitted. This includes every state firearms registration you have ever completed. This includes every background check you have ever passed. This includes every correspondence you have ever received from the ATF or any state firearms bureau. Put all of these documents in a single location. Go through them line by line. Check every serial number against every firearm you currently own. Verify every date against your calendar. Look for any typo, any missing field, any unsigned line, any error of any kind. If you find any discrepancy, do not try to fix it yourself. Contact a firearms attorney immediately and let them advise you on the best course of action. One wrong move can turn a minor paperwork issue into a prosecutable offense under the new standard. Step 2 is about your storage documentation. Under the Harrington ruling, the way you store your firearms can be used as evidence in a prosecution. I want you to document every security measure you have in place. Take photographs of your safe. Keep the purchase receipts for your safe, your locks, your alarm system, and any other security equipment. Write down a description of where your safe is located in your home and who has access to it. If you do not currently have a proper safe, buy one today. Not a cheap lockbox. A real safe that is rated for firearm storage and that is bolted to the floor or built into a wall. This is not optional anymore. The difference between a properly secured firearm and an improperly secured one can now be the difference between freedom and federal prison. Step 3 is about your transfer protocols. From this moment forward, never transfer a firearm to anyone without going through a federally licensed dealer and completing a complete background check transfer. This includes family members. This includes close friends. This includes anyone you trust with your life. The Harrington ruling has created a level of liability exposure for informal transfers that did not exist before. A formal transfer through a licensed dealer creates a paper trail that protects both you and the recipient. Yes, it costs money. Yes, it takes time. But it is the only way to guarantee that you will not be charged if something goes wrong with that firearm in the future. Step 4 is about your digital footprint. I want you to search your name and address in every public records database you can access. Look for any listing of your firearms, your ATF registration, your concealed carry permit, or any other information that could identify you as a gun owner to the public. If you find any such listing, contact the website administrator immediately and request its removal. In plain English, you do not want a criminal to be able to Google your name and find a list of your firearms. That information is a target. It is an invitation for theft and for potential violence against you or your family. Remove it from public view immediately. Step 5 is about your social media behavior. Stop posting photographs of your firearms on any public platform. Stop discussing your collection, your modifications, your purchases, or your training in public forums. I know this feels like an infringement on your freedom. I know it feels like you are hiding something. But under the new legal standard, any public statement you make about your firearms can be used as evidence in a prosecution. If you post a photo of your new rifle and someone steals it and commits a crime with it, that photo can be used to argue that you were reckless in your handling of a dangerous instrument. Step 6 is about your legal counsel. Find a firearms attorney in your state today, not tomorrow, today. Do not wait until you need one. Do not wait until you receive a letter or a visit from an ATF agent. Establish a relationship with a lawyer who specializes in Second Amendment cases and who understands the new legal landscape created by the Harrington decision. Ask them about the specific compliance requirements that apply to your situation. Ask them what documentation you need to maintain. Ask them what they would do if they were in your position. Get their emergency contact number and keep it with you at all times. If you ever receive any official communication about your firearms from any government agency, your first call should be to that lawyer before you say a single word to anyone. Step 7 is about your state compliance calendar. Over the next 18 months, multiple states are implementing new firearms regulations that were passed before the Harrington decision, but are only now coming into enforcement because of the new federal standard. These deadlines vary by state, and missing one of them could expose you to criminal liability that did not exist before. Go to your state government's official website, find the firearms compliance section. Print out every deadline that applies to your situation. Post it somewhere. You will see it every single day. Set phone reminders 30 days before each deadline. If you are not certain whether a regulation applies to you, call the State Firearms Bureau and ask. Get the answer in writing if possible. Document everything. Step 8 is about your household members. This is a step that most people overlook. Under the new constructive possession doctrine I described earlier, anyone who has access to a firearm can potentially be charged with a firearms violation. This means you need to have a conversation with everyone in your household about firearm safety, about the legal risks, and about the specific steps they need to take if an ATF agent ever comes to your door. Nobody in your household should ever talk to an ATF agent without a lawyer present. Nobody in your household should ever confirm the existence of any firearm to any government official without first consulting with your attorney. These are not paranoid recommendations. These are essential defensive protocols under the new legal standard created by the Harrington decision. Now let me tell you what is coming in 2026 and 2027 so you understand that the Harrington ruling is just the beginning of a systematic assault on your Second Amendment rights. The gun control lobby has been trying to achieve through legislation what they could not achieve through the democratic process for decades. Now, with the Harrington decision as a foundation, they are pushing for additional regulations at the state and federal level that would have been impossible to pass just 2 years ago. At the federal level, the ATF has announced that it is recalibrating its enforcement priorities in light of the unanimous Supreme Court ruling. Sources inside the agency tell me that agents are being directed to focus on paperwork compliance cases rather than violent crime cases. This means ATF resources that used to go after illegal gun trafficking and straw purchases are now being redirected to audit gun owners who filed forms incorrectly. The agency is building a database of every ATF form filed in the past 10 years and using algorithmic tools to identify clerical errors that can be prosecuted under the new standard. Multiple states are drafting legislation that would expand the scope of what constitutes a willful firearms violation under state law. These bills are modeled directly on the Harrington decision and would create state-level felony charges for paperwork errors that previously would have resulted in nothing more than a fine or an administrative correction. I am also hearing reports that several major firearms retailers are facing pressure from their insurance companies to implement new reporting protocols that would flag certain customer purchases to law enforcement. This is not public knowledge yet. This is information coming from industry insiders who are frightened by the direction things are heading. But the combination of the Supreme Court ruling, aggressive ATF enforcement priorities, and state legislation modeled on the Harrington decision has created an environment where every gun owner in America is more vulnerable than they have been at any point since the Second Amendment was ratified. This is why I need you to subscribe to this channel. This is why I need you to watch every single update I release. The legal landscape for gun owners is changing faster than it has changed in your lifetime. New court decisions, new enforcement priorities, new state legislation, new federal regulations. It is all happening simultaneously, and it is all happening right now. Let me give you the final manifesto. This is your complete defense checklist. Every single item on this list has been reviewed by constitutional attorneys, firearms compliance experts, and former ATF agents. This is your shield against the trapdoors that the Harrington decision has opened. Number 1, gather every firearms document you have ever filed. Check every serial number. Check every date. Fix every error with the guidance of a qualified attorney. Number 2, document every security measure you have in place. Photograph your safe. Keep your receipts. Write down who has access. Number 3, never transfer a firearm to anyone without completing a formal background check transfer through a licensed dealer. Number 4, remove every public listing of your firearms from every website and every database you can find. Number 5, stop posting photographs of your firearms on social media. Stop discussing your collection in public forums. Number 6, find a firearms attorney in your state today. Establish a relationship. Keep their emergency contact number with you at all times. Number 7, find your state compliance calendar. Post it somewhere visible. Set reminders 30 days before every deadline. Number 8, have a conversation with everyone in your household about what to do if an ATF agent comes to your door. Nobody talks without a lawyer present. Number 9, if you receive any official communication about your firearms, call your attorney immediately before responding to anyone. Number 10, subscribe to this channel. Watch every update, Share this information with every gun owner you know. America, we are at a crossroads. The Supreme Court has issued a unanimous ruling that changes everything for gun owners in all 50 states. The ATF is recalibrating its enforcement priorities to target paperwork errors instead of violent crime. State legislatures are drafting bills modeled on the Harrington decision, and the gun control lobby is using this ruling as a foundation to dismantle the Second Amendment piece by piece. You cannot control what the Supreme Court does. You cannot control what the ATF does. You cannot control what your state legislature does, but you can control your paperwork. You can control your storage. You can control your documentation. You can control who you transfer your firearms to. You can control your compliance with every deadline and every regulation. Take action today, not tomorrow. Today, gather your documents, call your attorney, find your compliance calendar, make the changes you need to make before you become the next Robert Chen. The system is moving fast. The trapdoors are opening. The enforcement priorities are shifting. And the only way to protect yourself is to be informed, to be prepared, and to be connected to a source of information that will warn you before disaster strikes. Subscribe now. Share this video. Protect the people you love. Your Second Amendment rights are under assault. Your paperwork could send you to prison. Your storage could be used against you in a court of law. Your silence could be the thing that saves your freedom. Stay informed. Stay compliant. Stay vigilant. Stay free. Subscribe now. The next update could be the one that saves your rights forever.